mode of carriage that I think, even if taking the right to bear arms seriously, we should respect that. If legislatures want to ban open carry and require concealed carry, that seems like an appropriate regulation. That doesn't burden the right very much, and that's probably should only get something like intermediate scrutiny, and is likely to satisfy that. The requirement of a background check and to get a shall issue permit, the shall issue permitting requirements, any court that hears a constitutional challenge to that, even one that takes the Second Amendment seriously, which not all lower courts have done, is going to look at those law-abidingness figures and is going to look at the fact that shall issue clearly allows the right to be exercised on a mass scale. It makes it a practical reality for most citizens. And saying this is a regulation that is narrowly tailored to the compelling interest of protecting the public safety. So my position will be interesting to see how much sword clashing there actually is here, is that the position Kansas has taken with permitless carry is not constitutionally required, but some sort of system like shall issue that allows the right to be exercised is. I'm kind of going to wait to the second part of this exchange to talk about some of the changes that have been happening at college campuses here on the University of Kansas. So I think, having made my basic position clear, I look forward to hearing what Professor Stacy has to say. Thank you.
First of all, I'd like to thank the Federalist Society for putting on this event, and Professor O'Shea for very interesting comments. I'm kind of the liberal dog who's trotted out with 5 minutes to provide a counterpoint. So let me do that. And I have 3 basic points I want to make. First, I don't think it makes any sense at all to rely exclusively on history in deciding what balance the Constitution strikes among 3 competing interests. One is the interest in making the right of self-defense effective. Another is, allowing the citizenry to prevent government tyranny. And against that, we have the need to protect public safety. I appreciate that Professor O'Shea appealed to prudential considerations. But if you look at the case law, Heller, for instance, in the lower federal cases deciding whether the right extends beyond the home, they purport to rely exclusively on history. Second, I don't think the courts do rely exclusively on history. That's really not what the courts are doing. And then third, I think we as a society need to confront, in modern circumstances, what is the appropriate balance between the interests that I sketched out. And when we think hard about the issues at stake, the conclusion I reach is that this matter ought to be left largely, if not entirely, to the legislative process. So Professor O'Shea's prudential arguments sound to me like very nice arguments to present to the legislature, to persuade the legislature to adopt a shall issue concealed carry regime. Okay, so you look at the cases and they purport to rely exclusively on history. For instance, the Ninth Circuit in Bonk recently upheld California's discretionary issuance of permit to engage in concealed carry regime. And in doing so, among other things, the majority relied on the Statute of Northampton, which was enacted by Parliament in 1328. And edicts of the English kings in the 15th and 16th century. Professor O'Shea, in some of his articles, and a lot of the lower federal court decisions, and the Supreme Court in Heller, relied on antebellum state court decisions. Doesn't make sense to rely on what the founders thought, or the Statute of Northampton, or antebellum cases? And my answer is no, it does not. Circumstances have really changed quite radically. You know, we don't have a frontier populated by dangerous wild animals and characterized by violence with Native Americans. We have terrorists and criminals who have semi-automatic and automatic weapons. Police don't ride horses. The police can be summoned by calling 911, and generally they respond fairly quickly. A tyrannical government now would have more than muskets and cannons, would have weaponized drones, nuclear weapons, stealth bombers. We've now had over 200 years of experience with our system of government, and regular elections seem to have been completely effective in preventing a tyrannical federal government from taking power and oppressing the citizenry. So in light of these differences, it strikes me as self-evidently absurd to rely exclusively on history. Second, that's really not what judges are doing. So in Heller, the Supreme Court read ahistorical limits onto the Second Amendment right. It doesn't apply to felons. It doesn't apply to the mentally ill. It doesn't apply in government buildings. There was no historical support for that. Also, everyone has to agree that a purpose of the Second Amendment was to enable the citizens to resist tyrannical government. Well, to be adequate to that purpose in modern circumstances implies a right to backyard possession of anti-aircraft weapons and basement nuclear weapons. But Justice Scalia said, oh no, it applies only to commonly held weapons. Well, that's really not supported by history. It's not the case that the founders had to choose between, you know, that a lot of people wanted to possess cannons. And so the founders made a deliberate judgment, oh, muskets and pistols, okay. Cannons, no. Unusual, sophisticated weapons, no. In one of Professor O'Shea's articles, he notes that that of the courts striking down various gun control measures, you know, Republican appointees were responsible for that. You know, that's really neither surprising nor troubling in my view, but it does show that judges are not relying exclusively on history. Okay, so you know, we need ourselves to resolve the questions of you know, what is the role of weapons in making the right of self-defense effective? What is the role of weapons in enabling citizens to prevent a tyrannical government from oppressing the citizenry? What about the need to protect the public? And, you know, I think questions like take the need or the role of weapons in making the right of self-defense effective. It can't be the case that anything that contributes marginally to making the right of self-defense more effective is within a constitutional right. Otherwise, people would have a constitutional right to possess machine guns and would have a constitutional right to possess handguns and airplanes, both of which in some circumstances would make the right of self-defense more effective. So how greatly does weapons have to contribute to the efficacy of self-defense to bring it within a constitutional right? It seems to me that that merits discussion, and it really hasn't been discussed. We can think of circumstances in which there would be a sympathetic case for requiring access to weapons to make the right of self-defense effective. You know, one situation would be a woman who has experienced domestic violence and threatened with death by an intimate other, and police in the area are not effective. Protective orders and the like are not effective. Or, you know, a pizza delivery person in a high crime area. On the other hand, we can think of situations where the role of weapons really doesn't contribute so greatly that it merits constitutional protection. And I would submit that requiring concealed carry in law school classrooms is such a situation. You know, the likelihood that that would be needed in self-defense and effective in self-defense, given the alternatives, you know, is not such that it merits constitutional protection. So it seems to me that the questions of how greatly does a weapon of a given kind in a given circumstances contribute to the efficacy of self-defense, how greatly does it threaten the public safety, these are questions that are debatable empirical questions. And they're the kinds of questions that are better submitted to the legislative process than frozen into the Constitution. A big reason for constitutionalization is a judgment that the legislative process would be inadequate to protect the interests in question. And it seems to me there isn't a strong argument to think that the legislative process will be structurally insensitive to the need to use guns. In fact, quite the opposite. The gun lobby seems to be very effective in preventing the legislative process from enacting gun control measures that the general public finds reasonable. Finally, and this is kind of goes back to the absurdity of originalism. In my view, we have to read the role of weapons in curbing government tyranny out of the Constitution. In modern circumstances, it just makes no sense. It is true that without sophisticated weapons, citizens won't be able to rise up against a tyrannical government. But the idea of people having backyard anti-aircraft weapons is just too threatening, and the need for it is just too remote, given the availability of regular elections, that this is a purpose that it doesn't make any sense to constitutionally protect anymore. So, too bad for originalism.
So to recap, to the extent that a right to carry arms for self-defense can be grounded in American historical sources, originalism is ridiculous and nobody really cares about it. But if arguments from state constitutional practice and the experience of Americans in recent times are offered, well, those are prudential arguments that you should address to the legislature. And also, you can't have a right to bear arms without having a right to bear nuclear weapons. So these are the sorts of arguments that essentially amount to a refusal to apply normal constitutional reasoning to this claim. And it's important because the debate about the right to keep and bear arms is not only important because of the individual interests in self-defense and liberty that are involved. By the way, do you think that a people that is armed and trained on its own might be more likely to be skeptical about sweeping police state measures that are proposed for them to vote on because they have the right to keep and bear arms and thus some ability to protect their own security? That sounds to me like the existence of the right to personal weapons serving liberty and restraining government overreach. And that goes on. It's moved to the western United States. Everybody who's ever talked about this going back to the founding era was perfectly clear that the sort of arms that were being talked about were the sorts of arms that